Okay, so welcome everyone to this Ethics in AI Colloquium, the first for the academic year, on the topic of the Meta Oversight Board and the self-regulation of tech companies. My name is John Tsoulis. I'm the director of the Institute for Ethics in AI. One of the most pressing questions thrown up by the use of AI and digital technologies is that of the division of regulatory labor between states, corporations, individuals, and other agents. In particular, the question, to what extent should tech companies be entrusted to self-regulate, and to the extent that they are entrusted with self-regulation, which regulatory standards should they apply? The UN's guiding principles on business and human rights are a starting point, but only a starting point in tackling this very difficult question. And it is a difficult question because human rights were initially framed, at least in the Universal Declaration, with states in mind, and the idea that we're living in a statist world where states will implement these standards. Things have changed. Corporations now have assumed much greater power. And the question is, can you simply apply standards that were fashioned for states to corporations, or do they need to be adapted? And as many of you will know, the guiding principles try to draw a distinction. They say that corporations have to respect human rights, whereas states have to respect and protect them, i.e. care about third-party compliance. But is that always going to be a viable distinction, for example, on online platforms? So this is an important question that we need to grapple with. And we're exceptionally fortunate today to have as our speaker Professor Paolo Carrozza of the University of Notre Dame Law School, who is not only one of the world's leading experts on human rights law, who has served as president of the Inter-American Commission on Human Rights and as a member of the US State Department's Commission on Unalienable Rights, which was chaired by Professor Mary Ann Glendon, but he is also a member of the Meta Oversight Board. Our commentator today is another leading authority on human rights law, Professor Kate O'Regan, who is the inaugural director of the Bonavero Institute of Human Rights here in Oxford and a former judge of the South African Constitutional Court, which is one of the most creative human rights courts in the world. So we're very delighted to have these two world-leading authorities on human rights to address one of the most pressing questions in human rights issues today, how we adapt them to the conduct of tech corporations. We have obviously the audience present here. We also have an online audience. I want to encourage the online audience to use the chat function on YouTube to put forward their questions. But now I'm going to invite Professor Carrozza to give us his talk. Thank you, Paolo.
Well, thank you very much, John, for the invitation to be here, and all of you for coming. And it's always wonderful to return to Oxford. It's such a rich environment, but especially for these issues that be honest up front, where we're raising questions that really often don't yet have answers. And we're struggling to find our way in new environments. And so to be in a place where we have the possibility of interacting across such a wide range of perspectives, experiences, interests, and so forth is really very, very valuable. I'll try to speak for just about 25 minutes, maybe 30 at the most, so that we have plenty of time for discussion, because there are many more issues to talk about than I will be able to make in my introductory comments. But let me begin simply with a brief description of the Oversight Board itself, as many of you may not be familiar with it as an institution and how it works. It is an independent body that was established by Meta, the parent company of Facebook, Instagram, and other platforms about 3 years ago to provide decisions on content moderation questions and to provide recommendations on more broad policy issues related to difficult content moderation policies and decisions that need to be made. It has been established in a way that is independent of Meta. It's run by a separate trust, of which Professor O'Regan is one of the trustees. And it is constituted by 22 members, a diverse and global group with extensive experience in a variety of different substantive and professional areas, diverse perspectives, politically supported by a very talented professional administrative staff. As I've already implied, independence really is critical here for the board to be able to accomplish its work. So its independence is guaranteed by financially by the existence of a separate trust that is independent of Meta and the trustees that run it. Essentially, we decide individual cases where people's content has been taken down, or cases where content has been left up on the platform, Facebook and Instagram, over the objections of other people and reported. And after going through the internal processes of appealing that, some of you may have gone through this process yourselves on different occasions within Meta, those cases and controversies can then be appealed to the board, and we select from among the appeals made. Now, a very important point right from the start needs to be illustrated. So far in its 3 years of operation, the Oversight Board has received approximately 2.5 million appeals. Okay? That's the first of many ways in which the challenge of scale is going to be central to the comments that I will make tonight. Of those 2.5 million appeals, we've decided 67 cases so far. Okay? That includes pending cases, so not even 67 yet. So the point here, very clearly, just you can infer from the numbers, is that we're not out to decide a large number of cases. This is not an industrial approach to content moderation where everybody gets a remedy through the Oversight Board. The challenge is to aim to use a selection of difficult and significant cases as entry points into addressing larger systemic issues of content moderation on these platforms at scale. Of those cases that we've decided so far, about 75% of them have overturned Meta's decisions, either to remove or to keep up. And the decisions that we make on individual pieces of content in each of these cases are binding on Meta, or I should say Meta has bound itself by contractual obligation to implement those decisions, both in the specific case and in cases, in parallel cases with identical content. But really, to be honest, the specific decisions of up or down is not really where the interesting, difficult, and important work is being done by the board. It is in the accompanying recommendations that go along with it. So in connection with any specific case, recommendations will be made, which are not binding, but which Meta has bound itself to respond to publicly, and you know, in the cases so far, we've issued about 240 different recommendations. Those recommendations go typically to these larger policy questions on community standards, on enforcement processes, on how automation is used, and so forth. I will say generally that it's a new body. It's unprecedented. There's no other body in the world like it yet, and we all have to acknowledge that it's still an experiment. It's an experiment that we want very much to be successful, and those of us who have agreed to serve on the board hope and we're doing everything we can for it to be successful. But we'll see, right? It's a work in progress. It's a work in progress. But I will say at least this much, I think, is clear. There was a fair amount of initial skepticism about the independence of the board and charges that inevitably it would be an exercise in whitewashing Meta's record. I think those objections have largely dissipated almost completely over the first 3 years. However, one might try to measure the effectiveness or not of the board. I think it's clear that I and my 21 other colleagues are decidedly not there in order to be apologists or to obscure the very large challenges of content moderation at scale and the very real problems that it raises in the world. We've weighed in on questions that, as in the words of one of the most acute scholarly observers of the board, Evelyn Douek has put it, constitute some of the hardest, most consequential questions about speech regulation in the modern world, questions about which there's profound, intractable societal disagreements. These include, for example, whether the President of the United States should be suspended from the platform, Meta's handling of COVID disinformation online, disputes about content relating to any number of conflict areas around the world, from Ukraine to Israel and Palestine to Ethiopia to Azerbaijan, Nigeria, Sudan. Hate speech, incitement to violence, anti-regime protests in Cuba, health and psychological concerns, especially relating to young people and, for example, extreme diets, gender-based violence, public nudity, government influence over platforms, including in particular here in the UK. Our currently pending cases alone deal with, for example, how to handle manipulated media regarding political figures, Holocaust denial and anti-Semitism, election-related disinformation, and difficulties of moderating content relating to the praise of terrorist organizations. So there are many issues that could be taken up tonight in the remainder of my comments over these specific controversies, but also institutional issues regarding the legitimacy and effectiveness of self-regulation and self-regulatory bodies in general, their relation to state regulation and other institutions of accountability. We're in a legal context that is extraordinarily dynamic, both on the regulatory front, with the Digital Services Act in Europe, for example, the splintering of the regulatory environment on a global level, and the mosaic of accountability that this creates, but we're also in an extraordinarily dynamic environment from a technical point of view. The rise of large language models, generative AI, as tools of content moderation, as well as sources of new challenges to content moderation, is acute. And I'd be happy to try to talk about any number of those other things in the question and answer afterwards, if you would like. But in the time that I have here, I want to focus rather on a different question. The question of, a question that really lies at the core or at the foundation of all these others as well. And that is, what is the normative framework that does or should govern the self-regulation of social media? And in particular, where does international human rights law fit into that normative framework? How do human rights norms shape the approach that the board takes? And what are the implications of that approach? What are its virtues? And also, quite honestly, what are its limits and difficulties and challenges? The overall point that I'm going to try to make is that I think the experience of the board, on the one hand, does show us that a rights-based framework can be helpful and indeed essential to thinking through these hardest, most consequential questions. But also, at the same time, that a framework based in international human rights law by itself is insufficient. Insufficient to address the full range of distinctive challenges faced by a global private company moderating expression at scale. And thus, human rights, while playing an important role, needs to be both developed in new ways and also supplemented by other sources of reflection on obligations and responsibilities. Now, the role of human rights in content moderation is not a new topic that I'm raising for the first time, of course. It's been an important part of the discussion for 5 years and more within the field. On the one hand, we have, for example, for many years, David Kaye, the Special Rapporteur on Freedom of Expression at the United Nations, the past one, dedicated his entire tenure largely to talking about the role of human rights in the online space, and has been an ardent advocate of the role of international human rights standards. My colleague on the board and one of the co-chairs of the board, Evelyn Oswald, has been a scholar who's written extensively in that area in support of it as well. Skepticism about the role of international human rights in this field has been a little bit less pronounced over the years, but has been present as well and raised in a sustained way on the part of a few scholars, including one I already mentioned, Evelyn Duac, over the same period of time. What is different today, I think, from when that conversation began, is that now we have 3 years of experience of the Oversight Board's work, which for the first time is, at an institutional level, not just talking about trying to apply international human rights standards, but actually doing it, for better or for worse, right? So there's a body that can be and should be evaluated critically. And most of that work still remains to be done. There's a recent article by Larry Helfer and Molly Land that does try to evaluate the human rights trajectory of the Oversight Board and comes out relatively positive on that. But they're mostly taking an approach that looks at the question of institutional legitimacy, which is slightly different, and comparing it to the other human rights bodies. So I'm going to get an approach that looks a little bit more at sort of the normative foundation questions. Now, a quick outline for you of where, in fact, in practice, international human rights norms get worked into the board's decisions. Meta adopted as an internal corporate policy the 2011 UN Guiding Principles on Business and Human Rights that Professor Tassioulas mentioned in his introduction. And this is the hook on which the Oversight Board hangs its insertion of a variety of international human rights instruments in its analysis. The International Bill of Human Rights, the Universal Declaration, and the two covenants, but also, as appropriate to whatever issue is at hand, other universal treaties, the Convention on the Elimination of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination Against Women, the Convention on the Rights of the Child, etc. But at the center of this, above all, the one instrument which is consistently in play for us in every decision is the Covenant on Civil and Political Rights, and very specifically Article 19, which protects freedom of expression. It has a place of privilege within the canon of norms that are being applied, because at some level, every content moderation decision is a question of freedom of expression or about appropriate limits on freedom of expression. And therefore, in particular, the limitations clause of Article 19 and the framework of analysis that it lays out regarding when limitations on freedom of expression are justified serves as the principal analytical framework that the board applies. So that means asking questions in each case about where there is a restriction on freedom of expression, what is the aim and is it legitimate? Has it been done in a way that satisfies standards of legality? And are the restrictions necessary and proportionate to the aim being pursued? Really, if you were to read the cases of the board, every one of its decisions undertakes that analysis to some degree. And usually it's the central core of the arguments being made. Even to the point, I will say from my point of view, that sometimes it has arguably become already a little bit too formalistic and formulaic. We can come back to that point indirectly. Now, I will say that I think some of the virtues of this approach are pretty obvious. Implicitly, and sometimes explicitly, this approach, embracing human rights at its center, places the value of human dignity, and let's be clear, universal, equal, inherent, unalienable human dignity of every human person, at the center of the analysis. In a context where it is very easy, ethically, to lose sight of the person and the value of the person, that is no small feat. That is no small contribution, right? Amid the gigantic dimensions of this problem, billions of pieces of content daily, to remind ourselves that at the core lies the dignity of every human person is an important starting point. It is a check, I think, against some temptations to an overly utilitarian and instrumentalist approach to ethics in this field, and certainly a check against a purely technocratic answer to the problems that we're facing. The second virtue is, of course, the virtue that the Human Rights Project has traded on since 1948, and that is a claim to universalism and the capacity to at least provide what is, for better or for worse, widely accepted as the closest thing we have to an ethically cross-cultural vocabulary and reference point. And this is apt for the global reach of social media that necessarily can't be contained within any specific cultural context or other one, right? And therefore, the problem that we're trying to, at one level, respond to in the global content moderation space is exactly analogous to the problems that Universal Human Rights Project is trying to respond to since 1948, right? The need to reach agreement across vast and intractable differences of ethical perspectives, religious perspectives, historical, economic, and political models, etc. And so it's not surprising that not only is there an emphasis on human rights within the board's work, but specifically on human rights at the most universal level, the UN instruments, not the European system, not the inter-American system, etc. A third virtue, I think, is that it makes the work of the board immediately part of a larger ecosystem of norm generation, norm diffusion, and institutions of human rights. So it establishes parallels to and links with other human rights bodies and stakeholders in this environment, which helps to give these difficult content moderation decisions a more public-facing dimension as well, and an entry point for many of the stakeholders in the process. And I think by doing so, it also helps to foster a certain degree of transparency of reasoning and of decision-making, because we are necessarily following certain established patterns already of normative discourse, right? So these virtues and others, I think, have contributed, importantly to the Oversight Board's success, the success that we have had in protecting freedom of expression, and also in balancing freedom of expression against other human rights in ways that I think belie some of the more cynical assessments of what the board's work might have been like at its origin. As a result of the board's recommendations, for example, Meta has created new policies, new community standards on misinformation, a policy exception for satirical content, has added significantly more transparency in policies relating to, for example, newsworthiness or dangerous organizations. It's translated its policies into new language, giving hundreds of millions of users access to the community standards that are being applied to them. At a more specific level, just by way of example, Meta recently implemented a board recommendation to allow the use of the phrase "death to Khamenei" in the context of the Iran protests. And posts after this implementation, we saw posts using this phrase increase almost 30% from before the decision of the board. A measurable and significant change for freedom of expression in and regarding Iran. There are other sort of consequences of implementation that I think are worth mentioning, but in the interest of the time, I will stop there unless people have more questions. I would say that there is a track record already at 3 years of some notable successes, right, here and in other cases. Now for the other side of the coin, though, right? And yet, there are undoubtedly very substantial challenges, unresolved challenges that arise in trying to use primarily a framework that is grounded in international human rights law. Some of these challenges arise from the gaps that Professor Tassioulis was referring to in his introductory remarks between a private company and a state actor. Others arise even more fundamentally from conceptual gaps between the scope and operation of human rights law and the demands and problems of global content moderation at very large scale and speed through automated mechanisms. Okay? Let me be a little bit more specific by mentioning what I think are four areas of major challenges in the use of human rights. One is that by its very nature, from its start, the problem that human rights is trying to address is one that inherently tends towards an individual focus, individualized claims of justice, right? That's exactly what gives the rhetoric of human rights its power, right? Is to say this person, her rights have been violated. She has a claim of rights in justice against this other person, this government, something that must always be done to that person or may never be done to that person. Okay. But the challenges that we're facing in the content moderation space are ones that largely involve very diffuse goods, very difficult to individualize, right? General goods that operate at a very vast scale. So it's a problem of a contrast with the very conceptualization of human rights at its origins. And that content is exacerbated when you take those diffuse goods and then you're moderating them over 2.2 billion posts, right? Or 100 million enforcement decisions a day on some platforms, okay? The model of individualized justice versus dealing with an environment that necessarily demands use of automation and with it significant error rates necessarily, means that we're often in the content moderation space necessarily asking what are the degrees and kinds of errors that we're willing to tolerate, right? That's not the way we've ever thought about human rights, right? Okay, we're gonna realize human rights here, and we know that there are going to be mistakes, and it's either going to be over-enforced or under-enforced, but that's just the reality. We wouldn't think of human rights that way. We have to think that way. It's a very different mentality from the individualized norms. A second challenge, I think, is that the very virtue of human rights of universalism, and this is true even within, strictly speaking, the traditional human rights space, is always in tension with context, with contextualization, with the realities of local knowledge, right? To use Clifford Geertz's famous phrase. Within the human rights system, there are various ways of mediating that universality with local realities and particularities. In part, the dynamics of state sovereignty, principle of subsidiarity. These effectively give greater capacity for human rights norms to be adapted flexibly to context, to tradition. Now, I'm not saying that this is always exercised well in the human rights framework, but the doctrines and institutions and practices are there to do so, okay? Norms, even the most universal norms, are almost always filtered and mediated through domestic institutions, domestic law, domestic politics, and advocacy, and therefore exist in dynamic tension with a local context. But when you move to a global platform, making content moderation decisions for all of its users, billions of people at a time, across a vast array of contexts, it's very difficult to build that context in, right? If you were to look at all of the decisions that we've rendered so far at the Oversight Board, I dare say that the most recurrent problem and challenge is how to take account adequately of context. There almost isn't a decision in which we aren't at some level telling Meta, go back and do a better job of taking account into context, because otherwise you're going to get it wrong, and you got it wrong in this particular case. Right? How to build it in is very difficult, much more difficult than it is in traditional human rights contexts where it's already a challenge. A third difficulty is the problem of positive obligations. Okay? In the human rights, in this sort of the human rights canon as international human rights law exists today, there is a limited but really important set of human rights norms that are regarded as generating affirmative obligations on the part of states, right? In other words, the traditional approach of human rights that is largely a negative restraint on states is still sort of the dominant paradigm of human rights, but in many contexts, tribunals and other forms of norm development have identified areas in which states have an affirmative obligation to guarantee human rights, okay? It's much less clear how that concept of positive obligations ought to be applied to private companies, okay? Human rights just doesn't provide, especially in the context of freedom of expression, guidance to when they ought to intervene to limit freedom of expression. The limitations clause that I referred to earlier tells us what the state actor, and therefore by analogy the corporate actor, what are the conditions for justifiably intervening in a way that restricts freedom of expression? It says nothing about when you should intervene. It's entirely discretionary on the part of the state, okay? And so the Article 19 limitation analysis helps us to conclude when it's okay for a state to limit freedom of expression, but not when it ought to do so, and still less when it should be compelled by human rights norms to do so in order to protect other human goods that are at stake. And yet, this is very often exactly the key question that is before the board, right? In the examples, in the areas of hate speech, graphic violence, bullying and harassment, and so forth, the question is, on what grounds should we conclude that Meta has an affirmative obligation to intervene here, to intervene in a way that limits, in some way, the freedom of expression on its platforms, okay? And that question, in turn, is very closely related to, I could list it as another point, but I'll just list it as sort of an ancillary point to this one, to the question of an assessment of what counts as harm. What counts as harm? What are the harms that we need to be attentive to? And how are they different in an online space than they are in a personal space or in a more restricted political community? The UN guiding principles say, in Principle 13, for example, they establish that businesses should prevent and mitigate adverse human rights impacts directly linked to their products, services, and businesses. But what counts as those adverse impacts, right, that harm, that triggers those responsibilities of prevention and mitigation? It's very difficult to identify, in large part because in many situations, many of these contexts, the harms that are being asserted, brought forth, are harms that don't exist at an individual level at a degree that would typically justify intervention, right? What makes them different, if they are different, is the claim that the scale of social media is so vast, the speed at which these communications are diffused makes the harms qualitatively different because they necessarily immediately have a cumulative value, and that cumulative harm is what generates the obligation to intervene, okay? Conceptually, that works. The problem is that there is, first of all, complete empirical uncertainty, as far as I can tell, about whether cumulative harms exist, how severe they are, when we should take them seriously. It's largely a question of assertion rather than verification in most cases, right? The second problem is that, the problem of, one answer to the first problem would be, in a situation of uncertainty, we're going to take a prophylactic approach, right? It's better to avoid the harms. But the problem with the prophylactic approach is that the problem of cumulative harms works in two directions simultaneously. It can also work in terms of harms to freedom of expression worldwide as a result of making widespread restrictions on freedom of expression on the basis of very narrow individual cases, okay? So one has to try to balance it. A third problem with just in a sort of uncritical way accepting the need to regulate on the basis of cumulative harms is that what corporations do in this space can, and especially if then legitimated by a body like the Oversight Board, have what Helfer and Land have referred to as negative spillover effects into what states do. Okay? States will say, Meta has the board, the Oversight Board, and Meta, in consequence of implementing the board, has acknowledged that cumulative harms justify widespread restrictions on freedom of expression, and therefore, we, the state, are going to start regulating to require companies to take that down. Now, why is that a problem? I mean, it might not be a problem if where we live is in a liberal, democratic, accountable rule of law system that adheres to fundamental rights, But in a world where we are increasingly in a context of rising authoritarianism, and including authoritarianism very specifically over internet restrictions and control, then those negative spillover effects ought to be areas of concern for us. The fourth and final area in which I think there are some difficulties in translating international human rights is what I'll just call very generically, and again it has many subparts, it can foster overconfidence in the virtues of legalism. Now I want to be careful here. I don't think that's a necessary consequence of human rights reasoning in the abstract. But I definitely do think, given my experience over 30 years working in the human rights field, that it is a risk given the specific way that international human rights law has developed over the last 5 decades, right? There's an emphasis on legalistic approaches. Many times that's a powerful and useful tool. But other times, as Joel Roth has recently said, Joel Roth is the former head of trust and safety at Twitter, now X. He lost his job because he was fired by Elon Musk. He recently referred to what he called content moderation's legalism problem. Now, what is that problem exactly? Well, first, it's the tendency to think about content moderation as being mostly constituted by very, very detailed legal codes. Okay? I'm a comparative lawyer by training, and so it immediately brings to mind to me the 19th century attempt in Prussia to draft a civil code. If you know anything about this, the Civil Code of Prussia was, its fundamental aim was to try to codify comprehensively every single decision that any judge might be called to make in the application of the code, okay? So in the end, it had 17,000 articles to it. And obviously, from a legal point of view, was a failure, okay, because of it. Now, we haven't gotten quite that far in content moderation, but there's definitely a tendency in that direction. Second, legalism also sometimes tends to over-privilege procedural answers at the expense of substantive ones. Process-based remedies substitute for directly addressing and grappling with the underlying difference of values that are driving the disagreement in the first place. In the Oversight Board's case, you see it emblematically in the decision over the suspension of Donald Trump, for example. A third problem with legalism is that it tends then to to push our decisions almost always to the question of proportionality. Now, proportionality is a good principle. I'm in favor of proportionality, but it need not be a principle that leads to arbitrariness, but it does lead to a high degree of discretion. The critics of proportionality, their critiques really, I think, come home here. The board is not embedded in a thick institutional, political, cultural, and legal context where there are checks and balances on it that can constrain that application. And so proportionally doesn't really operate like a rule of law so much as simply a justification for discretion. Now that's okay. We ought to be exercising discretion. But if it's cloaking what's actually going on, it's not always helpful, right? There are other problems with legalism as well. Again, in the interest of time, I won't go into them, but maybe they'll come up in discussion, right? But I just want to conclude in the last part by sort of then circling back to the bigger picture. Do these problems mean that the human rights paradigm as a whole is the wrong one for us? No, I would not reach that conclusion, and I hope you don't as well. In part because of the earlier helpful framing that it gives, which I mentioned earlier. It directs us to reason in certain ways, to ask certain kinds of questions. It gives us a framework of common reference and dialogue. All those things are helpful. I think it's better to say human rights have their role, and their role is essential, but their role is not exhaustive in this space. We need to develop, rethink, adapt, and supplement what has been conventionally the human rights-based approach to these things. We need to separate more clearly what is happening in this space from the way that we think about and apply human rights norms to states and governments. And a lot of that hard conceptual labor has not yet been done, right? David Kay, for example, who I mentioned earlier, says that there should be explicit and prior justifications by social media platforms when they depart from international human rights law, right? He doesn't say they shouldn't depart. He said when they depart, they should be explicit about it and justify it. Now that's a pretty good principle, I think. But to be honest, in our oversight board work, I'll be the first to say we have not yet taken a firm and consistent line requiring the companies to do that. It would be helpful, I think, if we did, right? And for that reason as well, it's an area that still needs to be given more structure and conceptual coherence. We've fallen short, I think, of the promise so far, and hopefully can insert ourselves more into that area in order to deepen and clarify the principles at stake. But even more broadly than that, I think that not only does human rights have a role, but I think we would actually be aided here by returning more systematically not just to the current rules of application of human rights law, but to the deeper roots of human rights law, the fundamental principles that they derive from, right? There's been a tendency over the decades of development of the human rights project, for completely understandable and legitimate reasons, to focus on increasingly positivized rules of application, right? And that's has been a way to try to make them more real, more effective, right? To back them up by positive law. But the problem is that, in doing so, it's almost like we've built a treehouse out of these human rights norms, and then having built it, we pull the ladder out from the ground because we don't need it anymore. Well, we need the ground still. We need to get back to the ground to understand what's going on here, right? This is where, although I think Evelyn Douak's skepticism about human rights norms in many ways has a justification, where I think I don't quite follow her critique, because her critique is mostly based, as I read it, on the idea that a rights-based assessment is an insufficient paradigm, largely because of the problem of the indeterminacy of human rights. And I'm not so sure that actually is a problem. I think in some degree, at least, the challenge is the opposite. In other words, we would benefit from engaging human rights at a higher level of generality, right? That might be part of the answer, how to draw on them without getting trapped by the constraints that come from using a tool that hasn't been developed to fit the purpose for which we're using it. So human rights has to be thought of not merely as detailed rules of decision that can and do serve that function sometimes, but also as broad and general principles that have an interlocking way of thinking about and articulating an integrated common good, right? That these principles that need to be harmonized with one another in many different ways. And that's an idea that was present among the drafters of the Universal Declaration. Jacques Maritain among them emphasized this, but that I think we've largely lost. We wave to it in the human rights field sometimes through references to the ideas of interdependence of rights, right? But we haven't really done enough work on what that really means, right? If we did, we could take the ideas of interdependence and indivisibility of human rights more seriously here as different aspects of a more comprehensive vision of human well-being and flourishing, both for individuals and communities. And that would give us grounds, I think, to discuss in a new and different way what human rights principles should exist beyond those that are the legal obligations of states in positive law, as universal moral claims grounded in human dignity, and build from that a more robust understanding of what the affirmative obligations of corporate entities should be, including specifically what they should be in fostering robust free expression across jurisdictional lines. It's an interesting sort of footnote here to me that the Oversight Board Charter refers to a commitment to follow human rights norms, not human rights law. Some people might regard that as a restrictive statement. I don't. I see it as a broadening statement, an invitation for us. An invitation that can also foster efforts to incorporate human rights perspectives in upstream discussions of product design, which is critical here. where they get built into the systemic functioning of algorithms and automated systems, and not just used post hoc in the correction and remediation of policies and actions that are found to compromise human rights downstream, right? So in all of these ways, I think there's a lot of work still to be done, but it's exciting work. It's work that really matters. It does make a difference. The challenges are enormous. The uncertainty is great. But I hope we can all sort of find inspiration from those challenges to rise to the occasion and press harder on these issues, both in theory and in practice. Thank you.
Thanks so much, Paolo. That was a really fantastic overview of many of the challenges that we're facing. And I hope especially some of the younger people in this audience will think it's right for them to take them up. As Paolo mentioned, he's a member of the Oversight Board, as I mentioned, but he mentioned that Kate is the overseer of him as a trustee. So that's a wonderful meta move that we can now proceed to. And I'll invite Kate to give us her response to Paolo's lecture, whichever you're most comfortable with.
Well, I might stay here because I think everybody can see me quite well. So thanks, Paolo. That was a really sort of bravo effect of an overview of how the system's working and the role of international human rights law in it. I wanted to take a step back before we get to that and identify why this is such a difficult problem. Because what one needs to remember, and let's use international human rights law or freedom of speech as a kind of core element within human rights law. If you think before we had the internet, before we had social media platforms, the main ways in which speech was disseminated were through publishers. Various forms of publishers or people speaking on platforms, but particularly large-scale publication was through publishers. And an enormous amount of all our thinking about how to regulate speech was really directed at that phenomenon. And once social media platforms, frankly, once the internet emerged, suddenly what you had was a complete flattening of who makes publication decisions. All of us, when we want to tweet, I'm afraid I still can't quite work out what the verb is to go with X, but tweet or post or put something on social media, we're the publisher effectively. And there are billions of us doing this on a daily basis. We don't carry very much legal consequences for that. If you look at the decision makers around publication in the heritage or traditional industry of press and publication, they carried pretty heavy responsibilities. Every time they decided to publish, they knew they may have to defend that against a defamation claim, against a breach of law or whatever. And a very careful decision tended to be made, particularly by people who had, who had something to lose if they got the assessment wrong about whether they should publish. That no longer happens. So really what we're expecting social media companies to do now is actually to pay catch up with the publication decisions that all of us have made. And of course, originally under still under US law, Section 230 of the Internal Decency Act says, you're not a publisher if you're an internet service provider and in some ways there's some realistic aspect to that. The publication decision is not being made by X or Meta or whatever, and a very similar provision applied under European Union law. So there is something very different that we're having to do now to try and protect the way in which speech happens. And I think it's important to realize that, because suddenly what you've got on a daily basis is this enormous scale, billions, languages, you talked a little bit about that, but the scale of the languages are important. And we're talking particularly about what is now called under the Digital Services Act of the European Union, very large online platforms with global reach. So they're very large, very powerful, very wealthy companies, but they are actually facilitating the publication of an enormous array of material. And now what effectively the task of something like the Oversight Board is to get them to regulate that almost entirely ex post facto. It is possible, and as my understanding is, Meta does it, and I think Twitter used to but no longer does, is there is a time lag between some image generation, so that if you post a particular image or a particular short video and it's already been identified as very harmful, it actually can be stopped beforehand. But that's by and large the exception. With all language-based posts, they land. The speed with which they reach the user is extraordinary, but of course we also know that the business model is an attention business model. So the attention business model is to drive things out that people look at. And we know that human beings like to look at things which are shocking, disturbing very often, or controversial, or with which they agree very strongly. So, and the algorithms that drive that process of attention, which is the business model, because the longer you look at these things, the more likely you are going to be exposed to adverts, etc. They look at to see how people are watching these things. And this is happening in split-second formulations. Now, our old model, which frankly is what the OSB is modeled on, which is to have a very careful legal analysis of whether it's harmful or not, by and large takes place 6 to 9 months later after all of this has happened. And by and large, 48 hours is probably the lifetime of a particular post or tweet or post. And so the match between the way our legal system is designed to deal with things, which is originally put pressure on the publisher to make sure that they don't break the law, just doesn't work under our social media environment. So I think what we're looking at with the model of the Oversight Board, and I completely agree here with Paolo, is to try, through the recommendations in particular, to try to ensure that Meta understands what is going to breach its own content guidelines. You didn't talk a lot about them, but this is a very important part of the principles that are applied by the Oversight Board and international human rights law, and to try to ensure that they know what those are, that they can train both their content moderators in the first place and the algorithmic processes to downscale things which are going to be problematic. And that itself is an enormous technical question as to exactly how possible that is. And I think there's a bit of a debate out there amongst people who know a lot more about how algorithms work than I do, as to how much of this is resistance, because frankly the attention model is the business model, and how much of this is really a technological problem. And I can't answer the question, but it's certainly an important one that we need to know more about when we're going to go on working in this sphere. So that's the first thing I wanted to say, which is it is something different to what we've dealt with before, and it's not just scale and speed, those are very important, but it's the ex post facto nature of the problem, which means that we're trying always to catch up with where we've got to. And for the moment, as Paolo said quite rightly, the OSB has got jurisdiction over posts left up or posts taken down. There hasn't been direct jurisdiction over algorithms. It's very interesting. I still don't understand what that would look like. I think there's a technical problem there, but there's also a legal question as to what it would look like. So there's certainly a lot more work to be done here. The second thing I wanted to talk about was just to respond in international human rights law. And I have no doubt that there is an enormous amount of value in international human rights law. It does focus our attention on really important issues, important claims, but it's not, I do think it's perhaps more problematic than we often think. So the first thing is to recognize that right at the heart of international human rights law is especially in the field of harmful speech, is a tension within the International Covenant on Civil and Political Rights itself, which, as Paolo said, is in many ways the lodestar of decision-making for the Oversight Board, as it should be, in my view. Article 19 is the provision which says everybody has got freedom of speech and we need to protect freedom of expression with certain limitations. Article 20 says states have an obligation under international human rights law to provide to prohibit harmful speech. That's not exactly the formulation, but harmful speech. Now, of course, we are all going to have a very strong view as to what we think harmful speech is, and it's very difficult. And that difference with in international human rights law is mimicked in domestic systems. And I don't think we should underestimate how significant the difference is in this terrain between First Amendment approaches in the United States and approaches under Article 19 and Article 20, under Article 10 of the European Convention, where in the United States there's this intriguing situation where the First Amendment is directed at state power. Congress may not limit freedom of speech, and that means all public sector. And that is an enormous tolerance under the American system for harmful speech. But that's, in other words, it says that the American law provides that Congress may not limit harmful speech unless it is really going to result immediately in harm. That is a very much more restrictive understanding than harm under Article 19 or under the European Convention of Human Rights in Article 10, where understandings of what is harmful speech are much more generous, and the duty of the state, which is the sort of Article 20 duty, is much more widely read. But there is, and this is where I absolutely agree with Paolo, here the context varies enormously. So I'm South African. In South Africa, thinking about hate speech, given our racial history, there's a certain needle to it, a political salience, which is very different to the salience of racial hate speech in other places, and that's understandable. And similarly in Germany, the political salience of speech denying the Holocaust is very different. And so these differences between different domestic systems, but also within international human rights law, do not provide answers to these questions, and they can't provide answers. And I think it's not surprising then when I read the decisions of the Oversight Board, which I think are generally extraordinarily thoughtful and well-reasoned, and I don't say that just to be flattering, but I really do think they're thoughtful, and I think you're seeing that in the scholarship, the drawing on this as a whole new resource in thinking about freedom of speech. But you do see division on these issues, and I think that's a relief. I think that's a sign of the body working. If you found these 22 people all agreeing on these things, I think there's something wrong. But it does mean that those things are going to go on being contested. It's unlikely the Oversight Board will be able to put an end to that contestation, save that there is a sense that there's been serious attention to the problem and thought, and people will see that. So those are really the two things I wanted to talk about. One was just to frame the way in which this problem has arisen as something that's quite novel and difficult. And the other is to say that I do think international human rights law has a role. So I think I'm largely agreeing with Paolo, but just to emphasize that actually it is not a system of norms that gives you clear, specific answers to questions, no matter how carefully you apply it.
Excellent. Thank you so much. Paolo, would you like to respond to anything Kate has said there?
Well, I think probably it's more useful to get questions from the audience and see where they are interested in taking this. So one thing that I would say, one small gloss on the Kate's initial comments about publishers and publishing is this. I'll be the first to acknowledge that, in my view, as in the view of many, the United States right now is doing a horrible job of trying, not even trying, of failing to try even to arrive at reasonable forms of regulation in this space. So it's just everything's paralyzed, right? But I say that mostly to go back and say, overall, in the history of the development of social media, I think the Section 230 approach has been a very useful one. It's protected freedom of expression. And I say that in particular to say the fact that we're all publishers has also had enormous benefits for human rights. Giving voice to marginalized communities that otherwise don't have voice globally, documenting human rights abuses, allowing for opposition to authoritarian regimes to flourish, and so forth. And so whatever approach we are going to take, like if we're going to start saying, the platforms maybe weren't publishers before, but now that they're curating in an algorithmic level the content in so many ways, we might as well treat them as publishers. My view is, whoa, let's be cautious about that, right? Because we don't want to, take steps that will have the inadvertent consequences also of depriving us of the many benefits that have come from this very open approach that we've had so far.
Yeah, I think I agree.
Before we go to the audience, and I would encourage everyone to think of a question, and also people online, I just want to ask you something about how you dealt with the fact that America is a kind of outlier in the human rights community. So one of the manifestations of this is a very robust doctrine of free speech that doesn't really accommodate the possibility that hate speech, for example, isn't really protected. Another thing where there's a difference is the doctrine of proportionality. So we did have a former member of your board, Jamal Green, speaking a couple of years ago, and he, of course, is a strong advocate of proportionality against the American model. So presumably the board would have had to come to some sort of view about whether it goes down the American route on free speech or not, and whether it accepts proportionality or the more rigid American approach, which says, well, if a right exists, that basically solves the matter. There isn't really much scope for balancing and resolving balances through some sort of trade-off. How did you go about that process, or how did the board go about that process?
So I think it's useful to think about it as a difficulty that exists on two different planes simultaneously, right? On the first sort of vision of what you'll see in the standards that the board applies and the decisions that are made is that question has been resolved against the United States approach, period. In the sense that right from the start, it was acknowledged that we're looking for meta needs, principles that are capable of having global application and legitimacy. So to apply just the norms of one outlier country, even if it's the major market of the United States where it's incorporated, doesn't really seem to work. So we're applying UN standards, and proportionality figures routinely into that in an unproblematic way, in the sense that nobody comes out and says, we shouldn't be using a proportionality analysis. That's just a wrong way of thinking about this. So it's there. But, of course, at a different level, all the same differences are still replicated within the arguments. This is what Kate was referring to when she says she sees and welcomes the divergences of perspectives of the board. They don't necessarily correspond to Americans on the board versus others. In fact, they rarely break down along American versus non-American lines, those disagreements. But they do break down very much over assessments of, well, exactly what does proportionality mean here? What kind of work should it be doing, right? For example, right? Or questions of, well, just how imminent should incitement be before we're going to allow a restriction on the basis of it, which is essentially replicating the difference between the American approach and the European one.
In your talk, though, you did reference the possibility that you could combine universality with an element of pluralism. So one question would be, why reject the American approach? Why not say, well, there's a plurality of standards that could be applied, and it could be for some contexts of American users, we're going to accept a more robust form of free speech, other contexts a different approach. And because we recognize that there isn't one canonical way in which, if you go back to the roots rather than the norms, if you go back to, rather than the rules, you go back to the roots of human rights, maybe the American approach to free speech in some ways is just as reasonable as the European approach. They've got different things to be said for them, so why not have a pluralistic outcome?
Well, and
enhance your legitimacy.
As you know, John, and close to my heart, but others wouldn't have any reason to know, I've been a champion of the principle of subsidiarity within the human rights framework throughout my entire scholarly career.
I wasn't trying to flatter you either, but
so I welcome this question. But I say that precisely because if others have sort of looked at the way that subsidiarity operates as a principle in the human rights framework, one way of characterizing it is that there are two different streams, right, of pluralism. There is the pluralism that results from a contextual appreciation of the facts on the ground, and there is a normative pluralism that accepts a differentiation in the actual norms that are being applied. So far, the board has insisted only on the former, right? A highly contextualized appreciation of the factual differences, a situation of crisis versus another one, a particular ethnic conflict or slur that means something in one place but not something in the other place, but has not yet opened in any way at all the door towards formally and explicit and normative pluralism.
Not openly, but maybe some of the cases categorized that way belong in the other box.
But there is one other thing to say about this, which is that the Meta community guidelines, the Facebook community guidelines, are emphatically a European Article 19 model. They have not sought to reassert a kind of First Amendment approach. And of course, that's one of the ironies about the First Amendment approach. In the US, if you're a private company, you can limit speech. If you are a university, you can limit speech. In Europe, that's much harder because there is an idea, actually, that free speech is not only about what the state regulates, but the notion that larger, powerful organizations have a duty to recognize free speech. So although it's very strong in the US in relation to the state not being able to control, private entities can control it as much as they like. That's not the case in Europe. So it actually cuts both ways, and I do think the Meta community guidelines have definitely opted for a kind of Article 19, Article 10 approach, rather than a First Amendment.
I'm so glad you raised that, and then this is one of the reasons why I pointed out that our divisions, even when they exist, rarely fall along the lines of Americans versus others. It's also because at least some of the Americans there are 6 of us out of 22 who are from the United States, okay? The rest are from all different other parts of the world. Even those 6 of us, there are at least a few of us, and I don't mind counting myself among them, who would say that at least within the US constitutional framework, the company itself also has First Amendment rights. And that means it has a certain degree of discretion that we would not allow to the state to restrict speech.
I'm just going to take a question that's come online because it's directly related to this. Luke Spajik says, lots of the issue here seems to be around taking context into account. Could national oversight boards feasibly overcome these issues? So great job creation scheme for human rights lawyers. Have you thought about that?
Well, I mean, I think we're necessarily having to think about it now because what we're seeing, in fact, at a global scale is a splintering of the internet into different national regulatory frames. That's what's coming. And it's coming, you see it more every day. The UK Online Safety Act just got royal assent. I don't need to tell you that, right? Is these national approaches. So we do need to think about that. I think that's highly problematic. I think it gives more scope to authoritarian governments, the more that happens, first of all. And second of all, I think it reduces much of the value that the internet has generated for us of communication across jurisdictional lines, across borders, right? I mean, one of our cases, just to give you one random sample, involved whether Meta should make an exception to its restriction on posts that are designed to solicit the exchange of regulated drugs, okay? But the reason that the exception was being claimed, desired, was specifically in the context of a health crisis in Sri Lanka, where those who were posting were soliciting antibiotics and other life-saving medicines from specifically the Sri Lankan diaspora community in the rest of the world. Okay? Now, it's a good thing, I think, right? We said there should be an exception because of that. But how does that work once you start having geographically bordered, nationalized regulations? Then that kind of cross-border solidarity becomes exceedingly difficult.
Okay. So, questions. Can we have Imogen there at the front. And wait, can you wait for the microphone and say who you are?
Hello, hi. I'm Imogen. I'm a student at the Institute. And thank you so much for the fascinating talk. I think I wanted to push you a little bit on the last point that you were just making to do with whether or not we need some national oversight boards as opposed to a certain kind of privatization that might seem to emerge in this. And I think I'm just worried about accountability and how you might see the accountability of tech companies evolving over the next few years with relation to content moderation decisions. And so, for instance, in the UK, then there are several cases sort of ongoing or recently concluded to do with, holding TikTok accountable for like data usage for children's data, and holding other social media platforms accountable for, really horrible sort of young people's suicides and things. Have been a few high-profile cases. And I suppose I'm wondering whether or not, if you're contracting into a relationship with an oversight board, whether that's going to be generating sufficient accountability for any of the decisions that are then made regarding content moderation.
I want to take some more questions. Again, can you say who you are and keep the questions succinct? So Isabel here at the front.
Thank you. Isabel Ferreras, visiting fellow here at the Institute. I would love to hear more from your perspectives as lawyers about the position that the oversight board plays within the environment of the corporation, that is Meta. So it would be, I'm a sociologist, you are legal scholars. We can think, just from looking at the situation from the outside, that this looks a bit like a Supreme Court, right? And so could you elaborate a bit on how you position the oversight board compared to the Supreme Court, the US, or what's the functional fit there within this corporate environment, and how specifically I would love to hear you more about maybe the legitimizing role that the board is playing or not in your view, so that we can understand better.
And the third question, because he's been holding his hand up for so long, Kyle.
Great. Yeah, thank you so much for your talk and for the commentary. It's super interesting, and I work on these issues directly, so I find it fascinating. And what I wanted to ask was, one worry I kind of have with the oversight board maybe is that you could risk kind of not challenging the prior step, which is like, I think the content moderation focus is interesting, but the further thing is the content amplification. So, like what Kate O'Regan was talking about was the fact that, the business model that's currently operating there is one that generates these insane negative externalities. And so I think the reason why, I think when you said the role of human rights norms are not going to be sort of like, you said they weren't going to be exhaustive, I think it's because we need to think about the fact that they're a corporation that is currently operating a particular business model that needs to be changed. And the oversight board can only do so much for, I think, the issues that basically are these like big systemic issues that the sort of social media corporations need to deal with. So I don't know what you think about the thought that like there's more to what corporations need to do besides binding themselves to independent organizations.
Yeah,
okay.
Great.
Go for it.
So fantastic, really stimulating and important questions. Thank you. Let me do the first and the third together because they really kind of overlap, right? Because of what I was focusing on in my remarks, and I said at the outset, where self-regulation fits in is a really important topic. That's not what I'm going to be talking about in my remarks. So I'm grateful for the opportunity to circle back to that and to say very clearly at the outset, I'm very confident that none of my other oversight board colleagues regard self-regulation, let alone the oversight board, as sufficient, right? None of us think that an environment that relies entirely on the self-regulation of companies is going to be adequate to bring accountability to this sphere at the levels in which it needs to be brought. We all see that self-regulation is a piece of a larger ecosystem of accountability that includes national regulators, international norms, civil society pressure, and stakeholders and advocates working together and collaborating. Now, to flip that around, though, I think I at least would also say you can't do it without self-regulation being an important part of that puzzle. There's too much moving too quickly. The regulators can't keep up. There's always going to be, whatever the public norms are, there's always going to be a margin of discretion and decision and internal policy making and so forth that's happening within the companies. So we also need, as part of the ecosystem of accountability, self-regulatory mechanisms that are playing a role. Now, their role is going to be limited. The Oversight Board, as Kate O'Regan mentioned, is our jurisdiction is already constrained over just certain kinds of activities of the company. We've been working hard to expand the scope of the board's decisions. Working, for example, at present we don't have decision-making authority over the takedown of accounts, only of content. Okay? We're working towards that. We didn't used to have jurisdiction over things like placing of warning screens. It was just an up or down decision. Now we have decisions about warning screens. So, it's a new and experimental body, as I mentioned. We're working on expanding accountability, the scope of our supervision. That said, I don't have any doubt that you're absolutely right, that there will be large structural questions about the business model itself, that it's not going to be, that we cannot and really should not expect that an independent body like the Oversight Board is going to make a fundamental incursion on that. That has to happen through other forms of regulatory accountability if it's going to happen. But I don't think that means that what we do is fundamentally, flawed or limited in its importance. It's just recognizing it's a piece of a larger mosaic. On the question of the sort of sociological reality of the company, again, a really stimulating question. I'm grateful to have a chance to comment on it. For all of the rhetoric that began with Mark Zuckerberg himself, that the Oversight Board is like the Supreme Court of Facebook, it's overblown. We're not, okay? And I think that's a bad analogy, to be honest. Precisely because we don't exist in a thick institutionalized context of divided powers and checks and balances and a history of institutional legitimacy and an overarching constitutional structure and so forth. I think the much better analogy is that we're much more like an international human rights tribunal, right? Where there's a distance, right? And the way in which you relate to the quote regulated entity is much more, has to be much more mediated through things like persuasiveness, through public shaming, through the marshaling of other constituencies, and so forth, in order to have its effect and its power, and the way that international human rights tribunals have developed. This is something that article that I mentioned and recommend to you by Helfer and Land really bring out in a very good way, I think, and very persuasively. The second point that I would make in regard to your question is this. Again, like an international human rights tribunal and a state, we internationally trained lawyers in particular, we have this tendency to reduce the state to a single monolithic thing, because juridically that's what it is, right? The state is a juridical person. But sociologically, politically, we all know that the state is a really complicated amalgam of different parts, different bodies, different institutions, different individual actors, and they often have very different conflicting interests, right? Interests that are also dynamic over time. And the way that human rights mechanisms become more effective over time is exactly by leveraging those internal differences often, right? Who are the stakeholders internally that are in support? Who are those that are opposed? How can we align ourselves with the former and, and take advantage of that? I say all of that because when you get a company as big and complicated as Meta, it's exactly analogous, right? It should surprise no one. I don't think I'm revealing any deep corporate secrets to say, in a company that has that kind of multi-layered, different responsibilities, work streams, actors, individuals, there'll be some who are much more supportive, advocates of the board internally, who are eager to take our norms and internalize them and make sure that they're respected. And there are those who are going to be much more skeptical and say, do we really need this? Can't we do this ourselves? Isn't it actually costing us more in reputation than we're gaining from it? I mean, and so you get the array of it, and that's dynamically changing all the time. And so, we board members don't work directly with Meta. We're very much at arm's length with our Meta interlocutors. The trustees work with Meta a lot more than we do. So I'd be interested if you have anything to say about this, Kate. But I think that at whatever level, it's a multifaceted dialogue with a variety of different interests simultaneously.
Kate, do you want to add anything?
Yes, I mean, may I say one thing about self-regulation, which is that I think what we need to recognize that in the entire sphere of human rights law, self-regulation and co-regulation in the area of free speech has the longest history. And that is because we have always been suspicious about the state regulating free speech, because they have actors in the state have such an interest in it. So, here in the UK, there's been a long battle to ensure that the state does not be the primary regulator of the press. There's a model of co-regulation. So we shouldn't be automatically skeptical about systems of self-regulation and co-regulation in this field, because we need to recognize, and Paolo's made the point, there are many states out there who would like to regulate, frankly, the internet out of existence. And increasingly, there are many of them who do it, who close it down all the time. So self-regulation and co-regulation has a long history in this sphere. It's an important history, and I think in some ways the OSB is carrying that idea forward. But it's not that I disagree with Paolo that it's the beginning and end of it all. On the relationship within Meta, I completely agree with Paolo. This is a very large corporation with very different interests at play. I think the one thing that I would add about it is, which I think is interesting, is there is a deep belief, I think, and I can't say whether it's right or not, but actually that a lot of the solutions to content moderation are going to be AI driven. Mm-hmm. That raises an interesting question about whether international human rights law and the mode in which we do it, balancing proportionality, etc., is susceptible to AI design. And I think the answer is probably not. And if you look at the way in which Meta has responded to some of the recommendations coming out of the OSB in terms of amending the community guidelines, and you look at also some of the kind of internal rules that they give to content moderators, they're formulated in different ways, trying to achieve the same outcomes, but actually it's not at all clear. And I mean, I think this is an interesting question for the intersection between AI and law altogether, is whether AI can do law in the way we've always done it, and whether it can do it in this area or not. Yeah. And that's a real challenge for the people in Meta who are what they call the product developers, people who are trying to respond to the recommendation, but actually that's by designing the way in which the technological tools work. And I think this is a whole area that we are only beginning to even talk about and think about.
I think it's a really important question whether you could reduce human rights adjudication to an algorithm. But even if you could, is it appropriate to have a non-human agent make human rights decisions? And that's a further issue. We've got 10 minutes because we started late, so I want to take 10 more minutes, provided there are questions. Right, so there's a question right there in the middle. And can I, again, insist that you say who you are and try to be succinct so we can get the most out of our speakers.
My name is Wagiti. I'm an MSc student at the Department of Psychiatry. You mentioned the First Amendment and the EU Convention laws, and commented on how the framework of the OSP, or the frameworks, tend to follow the EU Convention. And then you also mentioned countries like Sri Lanka and the benefits of social media in these countries. What I guess notice lacking is an appreciation of potentially the systems in these other countries where these platforms and systems are so useful, being considered in the decision-making capacity. And then perhaps maybe a question/comment on, if it is the oversight board, the Meta Oversight Board, but it works post hoc on posts that have already, been posted. I also just very clearly see the disconnect between what is being overseen. I just wonder. Yeah.
Another question? There's one down here.
Thank you very much. My name is Kristen Albrecht. I'm a visiting researcher at the Institute. You mentioned that you're looking for the universalist solution, and that getting back to the roots of human rights, especially human dignity, might help us to find better solutions. And I wanted to ask you whether you ever applied that in practice, and whether you could give us an example where it helped you, like getting back to the roots of human rights to make a better decision. And may I add a second question? What would you say, like, just from your personal opinion, but what role should democracy play in those private companies, and where could we, freedom of speech as like the root of democracy, but where does it apply, where is it processed in this private company?
And down here, Katya. One last question.
Hi, so my name is Ekaterina Hertog. I'm a fellow here at the Institute, and I am neither a philosopher nor a lawyer, so that's just to qualify my question. I was very interested in one of your earlier comments about the scale problem that you're facing, and I was, as neither a philosopher or a lawyer, I was wondering whether things were considered like, you also mentioned you don't have oversight of algorithms, which limits in, but I was wondering if there is at least an attempt or as a directional, or it would be helpful if eventually you had jurisdiction over algorithms, and whether we could regulate them or encourage them to develop in certain ways through goals and principles. Like many of us, I couldn't, you show me the code, I wouldn't be quite sure what it's doing necessarily, but whether there is sort of norms or certain values we can agree upon. And as an example, there's a lot of gray areas and a lot of things that work one way in one society and in a different way in another, but do you think there are some common things we could agree on? For example, I recently saw, I don't even know if it's fake news or not, but some statements supposedly Elon Musk was saying about COVID-19 and how people were dying because of ventilators or something like that. I don't even know if it's true, but if it was true and if it was promoted on social media, that is potentially very harmful for pretty much everyone, because it spreads false information about something that's life and death, potentially. So could we agree? Are there cases like that where at the extremes we could say, well, this should always be deprioritized? There is no conceivable environment, society, where we should promote this kind of information and encourage its spread. And my other thought was about transparency. And because an oversight board sounds like you're doing a great job, but there are 22 of you for millions of cases. So whether there is a potential for opening, not sure, but for opening some of consideration to sort of research community, whether there is a possibility of bringing in the public in some way to be involved in those decisions in some kind of democratic way. I think it's very challenging and very difficult to invent something like that, but whether there's thinking going around those ways. Thank you.
right? A very diverse array of questions. I'll try to keep them in my head because I didn't have notes to take. So remind me if I've missed them or misunderstood them. So starting at the beginning, I mean, the importance of social media in general in the variety of different social and political contexts around the world, but especially in the global south or in the countries of the global majority, if you prefer that terminology, is it's a concern that's very acutely present in our case selection system, right? And if you look at the cases that have been decided, they do not actually break down according to the proportion of cases that are appealed to us geographically. If we did, we'd be deciding almost entirely cases from the United States and Europe, right? But if you look at what we're deciding cases from Nigeria, Sudan, India, Indonesia, I mean, many other places where we receive fewer cases, but we acknowledge that the importance of weighing in on these issues precisely because of the role that it plays. On the question of speed and impact, I mean, look, we try to decide cases within 90 days of selecting them, okay? We can all acknowledge that, on the one hand, a human rights body that were to decide cases within 90 days would be crazy unheard of. When I was at the Inter-American Commission, some of our cases weren't decided for 14 years, okay? And ironically, some of those cases were about denials of due process because of delays in adjudication, but that's a different issue. And so 90 days is like, light speed from a human rights point of view. And we can also all acknowledge that 90 days is an eternity in internet time, right? So, how do we do it? I mean, I think the only answer is we go back to the question of saying, it's not really the individual case that we care about. I mean, we care about it, but that's not really what's important. What is important is, does the individual case give us a way to change, to have an impact on the policies and implementation of policies and enforcement of policies and the algorithms going forward so that the next cases are never going to happen, right? That's the goal. Okay. One was about human dignity and the other one was about...
Did you ever go back to the roots?
Yeah, but your other question also was... democracy. Yeah, so let me take the democracy one first because it was raised here in that way. That's a hard question to me. I don't really know that I have firm conclusions to draw. We've tried in the processes followed by the board in its decision-making process to introduce a democratic element that is intentionally more open than in many international human rights bodies. So in every case is opened up for public comment for anybody. And we make a point of deliberately pushing out the solicitation of public comments to any interested parties that we think might have information that would be helpful in views. And we get a lot of public comments in most cases, some of them extremely useful from very diverse points of view. So it's helpful. We also convene stakeholder roundtables on some of the harder cases and things like that. So there's that sort of democratic element. Meta itself has been involved in trying to develop a process that they've invited us to at least observe occasionally of democratizing content policy decisions and reforms. In collaboration with this outfit on the study of democracy at Stanford, they've convening this complex policy of stakeholder consultations in different parts of the world. I'll be honest, personally, I'm a little bit skeptical that it is going to have a big effect in actually democratizing in any meaningful sense the standards that companies develop and apply, but it's an interesting experiment. It's worth trying. I don't know. On the dignity question, so I'd say this. In particular, what I was hoping to emphasize at the end is that especially on the question of what is the source of the obligations of the companies here. That's where I think going back to the roots and the question of dignity is most useful. Because we can't just extrapolate the duties that Meta should have from the duties that we want states to have. It has to be different. And to get at that difference, I think it's useful to go back and say, look, there are important reasons. Here, I'll take a very American perspective on hate speech. You know,
I was waiting for this to happen.
Okay. There's all sorts of really important reasons why I don't want the US government to be deciding what constitutes hate speech and to re-regulating it, period. Okay? I want those decisions to be content neutral. Okay? But that's because of all sorts of concerns I have about criminal penalties and about the authority of the state and about the legitimacy of the state and about the way in which state power can be used to suppress diverse voices, etc. A lot of those concerns I don't have about companies, but it's not enough to simply say companies aren't states, so they should be freer. I think we also have to ask, what exactly is the dignitarian harm that hate speech produces? And under what conditions should we be concerned about those harms, right? Is it just because sometimes people are offended? I don't think that's enough. But I do think that there is a certain kind of dignitarian harm to systematic, widespread hate speech that goes, and especially in certain contexts, that even though I don't want a state to recognize it, and a better appreciation of the source of what it is that we're trying to protect about human people, right? Will help us to identify what should be the scope of the corporate obligation there. I think that's where it comes into play, right? Or can come into play, right? And then finally, remind me, please, I'm sorry.
It was transparency and democracy.
Oh, yeah.
Whether we can ever agree
Yeah.
certain goals, so that could be
Yeah. So I think there are sort of at least two parts to your question, as I remember it, on the question of algorithms that I thought was really helpful. One is, just to be clear, like, okay, we don't have jurisdiction over algorithms in a formal sense, in the sense that we can say to Meta, please show us the code, because we want to take it apart. Okay, we don't do that. But many of our recommendations go to the algorithmic moderation of content. I mean, we're constantly going to that. So in that sense, we do have, it is within scope, so to speak. We're always asking about, you know, how is the algorithmic moderation of this particular piece of content designed? What are the thresholds of certainty? What are the, you know, how do the classifiers work? Those are all algorithmic questions, and we do deal with them. But it's just, so the language is sometimes a little deceptive when we talk about this, in part because people talk about the algorithm. Well, there's no such thing as the algorithm, right? It's a whole bunch of algorithms that regulate all sorts of different, every little bit of content is regulated by an algorithm. It's not simply one coherent thing. And when we do grapple with it. Now, do we grapple with it in ways where, or I guess to put it better, are there ways in which algorithmic moderation we want it to produce results so clearly that we don't really have substantial disagreements about it, and we could all get behind it? Is that kind of what you were asking?
Whether the scale of the problem could be somewhat reduced if there were certain goals that could be, you know, passed on. Like, I don't know, never promote false information, remove false information about vaccinations.
Well, gosh, let me sort of get at it this way. There are almost no areas in the content moderation sphere. I learned this very quickly, even though I've not been involved in this for a very long period of time. One learns very quickly. There are almost no areas where you can get a universal consensual agreement that expression is so harmful it ought always to come down. Right? The closest that we get, I think, are in two areas. One is child sexual abuse material, right? Or CSAM, as it's referred to. Over CSAM stuff, nobody wants to see it on, and there's no dissent about it, right? The only dissent is, you know, whether companies have worked hard enough at identifying it and taking it down, okay? So that's probably the closest that we get. just behind that is the effort to prevent networks, platforms from being used to recruit, incite, and commit terrorist activity. And there also. But see, even there it starts to fray. I mean, like, you look at a group like Hamas and the atrocities that it just committed, and how do they coordinate that? It's all on Telegram, right? Telegram welcomes this stuff. Not only they don't moderate, they almost advertise themselves as, I don't use Telegram, I don't know if any of you do, as saying, like, you know, come to us. And so already you see sort of a fraying. Why? For economic reasons, I suppose, if you want to be cynical about it, that some companies have, you know. So I emphasize that only to show how difficult it is to really reach a truly universal consensus that this harmful material has to come down.
And on that note, I think we do have to stop. So can we thank Paolo and Kate for a really invigorating discussion. That was really excellent. Great discussion.